Please continue.
Simayat, the co-counsel, and I am here to address the issue number 3 and issue number 4 respectively. Before going to the issue number 3 to define it, it will be in order to state the instant facts of the case. I think it will. I think my counsel has already described before the honorable courts the facts of the case. So I would like to address the issue directly. So issue number 3 says that section number 306 to section number 308 are either violative of Quranic text or Sunnah or not. The council would answer in negative that section 306 to 308 are not violative of any Quranic text. Your Honor, as you already know that the most authoritative text or most authoritative book in our Islamic law is Quran, and the council would like to put reliance on the verse number 178 of Surah Al-Baqarah, where the concept of diyat has been mentioned. As you know that section number 308 and its clause 1 is mentioned that in case where qisas is not enforceable, then the offender must be punished by way of diyat, and the concept of diyat is given in verse number 178 of Surah Al-Baqarah. I will now go to my next submission. In Muhammad Nasir versus the estate, it was plainly held.
Council, read the verse of Surah Baqarah. What it says.
Yes, Your Honor. To avoid any misconception, I will read from the memorial. Sorry for inconvenience. Oh my goodness. Yes, Your Honors. It says the Surah Al-Baqarah, verse number 178, is translated as under: Believers, retaliation is ordained for you regarding the people who were killed, free versus free, captive versus captive, woman versus woman. Whoever is forgiven by brother of the slain for a price, let him abide by the customs and pay the price well. The council would like to formally put reliance on the last verse, last line of the verse, which has given the concept of diyat. In the instant case, therefore, the qisas is not liable as Mr.
Council, have you read the next verse of this surah? Verse 170, 180.
Yes, yes, Your Honors. I am reading the verse number 178 of Surah Al-Baqarah.
No, 179.
My apologies, Your Honor. I have not studied next verse.
Can you find it just right now and read it?
Yes, Your Honor.
Please. Council, and just find it, and if you can find. You can also read in Urdu, no problem.
The council would seek permission to recite surah, its translation in Urdu.
Yes, please.
29 verse of Surah Al-Baqarah states in Urdu, और तुम्हारे लिए किसास यानी खून का बदला लेने में ही जिंदगी की जमानत है, ए अक्लमंद लोगों, ताकि तुम खून रेजी और बर्बादी से बचो.
So, Council, what do you think about this verse?
Your Honor, Your Honor, the council would most respectfully disagree to apply this instant verse on the instant case, because Islam has always given easement in life, and therefore the council would request to have recourse to verse number 178 of Surah Al-Baqarah, where it has also been said that diyat must be given in case, and also if we will go further to address this issue, the Pakistani laws, which are also in conformity with the injunction of Islam, are plainly saying that where qisas is not liable, then the offender must be punished. Yes, Your Honors.
Yes, in verse number 178, it is mentioned that whoever is forgiven by the brother of the slain for a price, let him abide by the custom and pay the price well. Now, who is
Yes,
brother in this instant case? Who can forgive
yes,
this?
Your Honor.
Who is brother?
It must, yes, Your Honor. It must be deduced from this verse that brother is also a wali. Here, the concept of wali is given in this verse. If brother is a wali of any deceased person, then he may be a person who is able to claim qisas. But
Counselor,
since in the
how are you deducing the meaning of this term brother?
I am coming towards it. Islam has given the concept of sharers, and in case there is no brother, then obviously the son of a deceased person or offender, in the instant case as it has been provided, would be a wali of that offender. The devolution of this right of wali will goes on to Mr. Ali, who in the instant case is son of offender, our petitioner, Mr. Ahmed.
How are you saying that?
I have already mentioned, Your Honors, that there is a concept of devolution of right of a wali, because as it has been plainly said in this verse, that brother has such right to forgive the murder and thereafter receive the blood money. Since the brother is also a wali, so we can deduce by interpretation of this verse.
Counsel court always relies on the references and judgments, not on the deductions and presumptions. So
Yes, Your Honor, you're right.
do we have any judgment in this regard?
Unfortunately, Your Honor, the council have not taken recourse to this point, so council ignores. My apologies, Your Honor.
If you haven't taken any recourse to this one, it means that the qisas can be violative of Quranic text and Sunnah.
We surely cannot say that, because unless we have not taken recourse to the interpretation of this verse, this never suggests that there is no concept of diyat. So therefore, diyat, i.e. blood money, can also be given in case where qisas is not enforceable, or where qatl amd is not liable to qisas. In these cases or in these scenarios, the offender must be punished with under section 3081, which have given concept of diyat, and it is supported by this verse.
Counsel, do you think that this instant case falls in category of qisas?
My apologies. Can you repeat the question?
My question is, this case does fall in the category of qisas and punishment of qisas. Is this a crime related to qisas?
Your Honor, it is an admitted fact that Mr. Petitioner had committed the crime, and it would have been liable to qisas if Mr. Ali was not son of Mr. Petitioner, that is Mr. Ahmed.
No, before
If
applying
because
before applying to section 306 and 308, you must put your case in the field of qisas. If there is no field of qisas, then you cannot apply section 306 and 8. So how are you saying that this is the case of qisas, punishment must be qisas?
no, I'm not saying that this is a case of qisas. I am deteriorating from that point. I am saying,
If you are not saying that this is not related to qisas, then how are you applying section 306 and 8?
Your Honor, Section 308 and its Clause 1 directly applies to the instant case, because since Mr. Ahmed cannot be punished under Qisas, given the fact that Mr. Ali is son of Mr. Ahmed, and within the within the meaning of Section 305, it has been said, it has been already proven by my counsel that Ali is a wali of Ahmed. So when this situation arises, that when a son is direct descendant of offender, then qisas shall not be enforced, Your Honor.
Counsel, listen me. Section 306 and 308, they are actually leniencing the punishment of qisas. But before leniencing the punishment of qisas, we have to find out that whether crime falls in the punishment of qisas or not. Is this related to qisas or tazir? If it is related to qisas, then we can go to our section 306 and 8. So my question is whether it falls in the category of qisas or not. And if it falls, then what are the section provisions which you shall refer?
Your Honor, I have already said that in the instant case, Mr. Ahmed is not liable to qisas, although class 1 of section 308 does apply to the instant case. We cannot ignore the relevant provisions. Although it is true that his crime is not liable under qisas, because, given the facts that Mr. Ali is a descendant of Mr. Ahmed.
You are saying that you're saying that in this case, this crime is
Now
not.
I will turn. Now I will turn to your next question, that whether if qisas is not applicable here, then it should be punished with under section 302 or tazi. It should be punished under tazi. It is my next issue that will be addressed in the due course of time.
Okay, move on.
Yes, Your Honor. Your Honor, the next most authoritative source that this court has already relied upon is a case titled as Mohammad Nasir versus the estate, in which it was presumed that the section 306 and 308 are not violative of any Quranic text or Sunnah, because the opponent sides were not able to have recourse to much research on that particular issues. So the court had taken presumption that section 306 to 308 are not violative of any Quranic text. Now the council would like to address the issue number 4, and
Counsel,
yes, Your Honor.
Counsel, in which cases, qisas is Qatl Amd is not liable to qisas?
Your Honor, in this regard, we should consider section 306.
Yes, please read it.
Yes, Your Honor. Your Honor, Section 306 addresses your question. It says that Qatl-e-Am not liable to Qisas. Qatl-e-Am shall not liable to Qisas in the following cases, namely, A, when an offender is minor or insane. Since this does not relate with the instant case, so I would move on to Class B. When an offender causes death of his child or grandchild, how low soever, and this does not also apply in the instant case. Class C of Section 306 would apply to this instant case, which says that when any wali of the victim is direct descendant, how low soever of the offender. This is a case where a Qatl-e-Am shall not be liable to Qisas. And Your Honor, since Mr. Ali is direct descendant of Mr. Ahmed, so this crime, that is Qatl-e-Am, is not liable to Qisas in the instant case.
Counsel, issue before us is Section 306 to Section 308 of PPC are not violative of any Quranic text or Sunnah.
Yes, Your Honor. I have already addressed the issue that Section 306 and 308 are not violative of any Quranic text.
And you
in
have
this regard,
submitted before us. Right. Now, okay, right. Now my question is, Section 306 Clause A says, when an offender is minor or insane, then Qisas is, Qatl-e-Am is not liable to Qisas. Can you
Yes, Your
support
Honor.
this section with any Quranic text where it is written that if an offender is not liable to Qisas, or worse of the Quran?
My apologies, Your Honor. The question has been recorded with full enthusiasm and it will be researched further. My apologies.
Okay. I have also gone through your memorial and you have done very good and you have gone through Section 307 and you have dealt with it clause wise, but you have not mentioned specifically Section 306 and 308. So Section 306, even clause B, C, can you support these sections with these subsections with any Quranic text or Sunnah?
Yes, my apologies, Your Honor.
Okay, continue.
With your permission, the council would now move on to address his issue number 4, which is whether the punishment recorded under Section 302.
Hello, counsel. Before going to issue number 4, I wanna ask that can you refer us any sunnah which is not in contravention with this section 306 to 308? Yes, we have discussed Quranic text that is not in contravention, but will you refer any sunnah?
Unfortunately, Your Honor, I cannot at the instant moment.
Okay, no problem. Move on. Issue number 4.
Your Honor, the issue that I am going to address now is whether the punishment recorded and under Section 302 is appropriate or not appropriate in the scheme of law. The council would answer in negative. Your Honor, Tazir is defined in Clause L of Section 299. Your Honor, Tazir is applied. The Tazir is such a punishment which is given when there is no when the punishment of qisas or arsh or daman is not available to be inflicted. And Your Honor, tazir is the total discretion of the court, which should be applied judicially in the judicious manner. It has been provided in the commentary of Mr. Muhammad Mahmood that this tazir punishment should be given to the offender, having recourse to the full facts and circumstances of the case. As it has been said in the instant facts that Mr. Ahmed has lived a life that was mentally unstable, and he faced a lot of problems, including the separation of his father and mother. And when he married to her wife, Miss Samira, she also left him with his child. This had further, deteriorated the conditions of Mr. Ahmed, and whereafter he became impulsive and lost self-control and committed this crime. Your Honor, the counsel would now argue that where Qatl-e-Amd is not liable to qisas, then the punishment should be recorded under section 308 and its clause 1, which says that diyat money should be given to the walis of the victim.
Counsel?
Your Honor, the courts below has not
Hello,
taken
counsel.
recourse to
I
the
have a
section.
question, counsel.
Yes, sir.
Please read.
Sorry?
Please read section 308, subsection 2.
Okay, Your Honor. Your Honor, section 308 reads, punishment in Qatl-e-Amd not liable to qisas, etc. Where an offender guilty of its clause 1 says that where an offender guilty of Qatl-e-Amd is not liable to qisas under section 306, or the qisas is not enforceable under clause C of section 307, he shall be liable to yet. Should I read the
Subsection 2.
provisions of this
No,
section?
subsection 2. Subsection 2.
Honor.
Section 308.
Notwithstanding anything contained. Yes, Your Honor, I'm reading section 308 and its clause 2.
Yes.
Notwithstanding anything contained in subsection 1, the court, having regard to the facts and circumstances of the case, in addition to the punishment of diyat, may punish the offender with imprisonment of either description for a term which may extend to 25 years as tazir.
Counsel, can this subsection not be applied in this instance?
Your Honor, in this section, it has been said that the court must have recourse to facts and circumstances of the case. These are the provisions that should be applied in the case, because it seems that the courts below have not taken recourse to the facts of the case. As Mr. Ahmed has lived a life that was throughout his life was unstable, mentally unstable, and he was not able to make quite familiar decision which a rational person would have made. And in this regard, Mr. Ahmed had not made any rational decision to commit this crime. So these facts must be considered, and punishment should be given accordingly, and it should be recorded in the section 308 and its class 1, not class 2. Your Honor, in this regard, I must.
But again, Tazir is on the discretion of
I
court.
must have an. Yes, Your Honor.
You know that Tazir is on
It
the
is the
discretion of
discretion
court.
of. Must be Yes, Your Honor. It is.
So when it is on the discretion of court, then we can go under section 308 subsection 2.
Your Honor, the counsel has already argued before the Honorable Court that the recourse must be taken to the facts and circumstances of the case while using say class 2 of section 308 and the courts also have not taken recourse, it appears.
Okay, so what must be the circumstances of the case when this objection shall be attracted? What would be the circumstances of the case when we can apply this?
Your Honor, as it has been mentioned in section 308, yes, Your Honor, it has been said in the erstwhile section 308 and its class 2 that it is the duty of court have regard to the facts and circumstances. Since this is the duty of the court to decide that what are the facts and circumstances of the case and chances of this incident case.
So,
And I have already
counsel, we can
laid
see
down the
that
circumstances.
circumstances of the case bound us to apply the subsection 2 under the. You can see that circumstances of the case can make this case to be applied. Section 2 be applied.
Sorry, Your Honor. Your Honor. My apologies. Can you repeat the question?
When you say that it is duty of the court to go through the circumstances of the case, you can see from your
Yes, Your
argument
Honor.
and from the arguments of your co-counsel that this is making such kind of circumstances of the case, which is making it bound to apply section 308 subsection 2. We have gone through all and we are now going to apply this subsection 2. Then what should you say on this?
Your Honor, it appears from the facts that this class should not be attracted because as Mr. Ahmed, the petitioner, is not also liable to Qisas, then the section 302 in class B can never be attracted in the stud case because the circumstances of the case suggest that this punishment under Ace Tazir is inappropriate, having regard to the case, to the facts and circumstances.
Now let's see the circumstances of the case. A person named Mr. Ahmed has killed his wife brutally by throwing acid. Besides, he also threw the same on the family members. Besides, he also threw the same on his minor son, Mr. Ali. Are these circumstances not enough to apply Section 308 subsection 2?
Your Honor, the language of section 306 is clear. We have already taken recourse to that. Since this Qisas is not applicable, then the court it is not the duty of court to record the punishment under section 302B to death. In this regard, I would like to put reliance on a case titled as Khaliluz Zaman versus Supreme Appellate Court. Its citation is 1084 SCPLD 885. In this decision, it has been held that if the statute does not provide death penalty for the offense, then obviously the court would have no jurisdiction to award the same. And so, as such, the conviction and sentence of petitioner recorded under section 302 PPC is coram non judice. It has been plainly observed by the Supreme Court of the Pakistan that where it is not the duty of court that the section that where the statute does not apply to the cases, then it is not the duty of court to have recourse to this section and apply those sections.
Counsel, for the sake of your arguments, we are not going to apply section 302. We are applying section number 308 subsection 2. We are applying Tazir under 308 2.
Your Honor, I have already laid down my arguments before you that the regard must be taken in this regard to the facts and circumstances of the case, Your Honor. All I have to say is this.
But court is not satisfied on these grounds.
My apologies then, Your Honor.
Okay, proceed on.
Before concluding my argument, the council would like to put reliance on another case of the Supreme Court of Pakistan, which is titled as Zahid Rahman versus the state. Uh, you know, in in this case, it has been again held by the Supreme Court of the Pakistan that no death or the punishment of life imprisonment should be inflicted as tazir, but it should be mild in nature. The court must have regard to this precedent of the Supreme Court, where it has been held that the punishment of tazir must be mild in nature, and also having regard to the circumstances and facts, it appears that attracting section 2, attracting class 2 of section 308 would not be the duty of the court. Since
Counsel?
25 years, really very huge and not mild, having regard to the circumstances. Beside the case title before you.
Counsel, I'm going through your memorial and come to page number 26.
Okay, Your Honor. (26), Your Honor?
Yes.
Yes, Your Honor. I'm at page number 26.
And there's the title Insanity of Mr. Ahmed.
Yes, Your Honor.
Now, issue before us is Tazir is appropriate or not. So, how you are arguing the insanity
Yes, Your
of Mr. Ahmed?
Your Honor, this is the statement of a grief fact that the condition, the mental condition and mental stability since the childhood is his family was within the quarrels since his child, and this further deteriorated when his parents got separated, and it further deteriorated when his business was badly crashed when when market was crashed, his business failed, and this has further deteriorated the mental condition of the petitioner, because mental condition is the statement of a grief petition has been weekly of PPC, where it has been said that the punishment should be mild in nature, where the offender is insane.
Okay, counsel, conclude your arguments.
Your Honor, I would like to come on my final argument, that is the Constitution of Pakistan. You know, our Constitution has given really much importance to right of life, that is defined under section under Article 9 of the Constitution of Islamic Republic of Pakistan, which saves the inherent right of a person of life. Uh, while while courts are giving punishment of death, they should consider the supreme law of the land, and they should have regard to that erstwhile article of the Constitution of Islamic Republic of Pakistan, which have given huge importance to life. In this regard, the council would put reliance on a case reported as Ms. Sheila Zia versus the Wabda. Unfortunately, Your Honor, this case has not been given in memorial, but with your permission, the council would like to put reliance on this case titled as Sheila Zia versus Wabda, in which the term life, which is used in Article 9, has been very gorgeously defined, and it says that life does not include only the right to life from life and death. It includes all such rights which are necessary to carry on life in a proper way. So it, it, the term life also includes the right to access to justice also. In this regard, the courts below have not taken course and have given punishment under Section 3. Assume that they have not taken recourse to Article 9 of the Constitution of Islamic Republic of Pakistan. Thank you, Your Honor.
Okay.
In the end, the council would like to pray before this court that the punishment recorded under Section 302 should not be enforced. यार कम
Okay, thank you so much.
दुखियो वॾी तयारी ये सभई सवाल नोट कयो ज़ैब जमाली साहब ऐं ये ग्रुप में मोकिलियो वॾो यार वॾा सवाल लेकिन
हिकिड़ो
यानी हिन में त आहिनि बि न मेमोरियल में उनजा जवाब बि न आहिनि
बस हाणे ॿियो हिकिड़ो सेशन रखूं था हींअर ई हुन में डिस्कस कयूं था हिन टाइम ख़तम थी वियो आहे
कोई बात
जी
नहीं डिस्कस करो ऐं मानी खाई जा
हाँ
हा
1 मिनट वेट कजां न 10 मिनट वेट कजां तो बस पोइ ख़तम था थियूं
10 मिनट खां पोइ बस शुरू थियो सभु
हाँ?
मां चयो 10 मिनट खां पोइ हर को बानी वग़ैरह जो सिलसिलो शुरू रखे
हाँ बस 10 मिनट वेट कयो खोसा 10 मिनट वेट
हा
कयो
डिस्कस कयो